Good afternoon, everyone. I am Andrea Guido. I am a lawyer from Genoa. I need to give you some indications about the 4 directives that have been assigned to me, which have been perfectly framed, perfectly listed, and perfectly described in general by President D'Antoni. That is, the issue of the right to deduction and the interpretation of acts that concern us, because in extradition proceedings there is an element, how can I say, generally problematic, for which there is always this issue, the issue of information, the issue of legal representation, the costs to the state for minors, which we won't discuss, as it serves no purpose. Why are they important? Because we have implemented, let me make a brief introduction in these meetings on European Union law, on how European law works to understand the working spaces of defenders and to understand how it functions. President D'Antoni explained very well that there was the Stockholm Roadmap, and they adopted these directives, which then need to be implemented with internal measures that you can find on the website curia.eu. Country by country, there is a list of all the measures adopted in relation to the individual directives by all 27 countries of the European Union. So they are introduced in all languages because the Union translates everything, including into Italian, for what concerns us, so they are perfectly known. He explained to us that the directives must be implemented in the domestic legal systems within a generally 2-year period, which is stated at the end in the last article of these directives. In our case, the mechanism is a legislative decree, so it is a matter of executive power with the transmission of acts for mandatory but only consultative opinions, not binding to the chambers. After 60 days, the legislative decree is published in the official gazette. We mentioned 4 directives. Directive 64 of 2010, the interpretation and translation of acts in criminal proceedings. It is a directive that obviously concerns the merits phase, but there are specific provisions regarding European arrest warrants, because the mechanism involves both the merits phase and the execution phase, which are equal from the perspective of Union law. Therefore, the minimum rights that were explained in the first report, which must be uniform across all legal systems, must be guaranteed both in the merits phase and in the execution phase. Let me give you an example. Article 2, paragraph 7 of the directive. I read it just to clarify. Then I repeat, you can find everything in the attachment in the slides. In the execution of a European arrest warrant, we are in the phase where a foreign warrant is executed in Italy. Obviously, we deal with this, the executing member state. Therefore, the EU law is generic, ensures that its competent authorities provide the assistance of an interpreter to individuals who are subject to such proceedings and who do not speak or understand the language of the proceedings. Here, obviously, there can be 2 languages because there is the language of the process, let's say, of Germany. But the person subject to the European arrest warrant, whether it is for prosecution or execution, can be German or Senegalese or whatever. So they may speak another language altogether, while the executing legal system is Italian, meaning there can already be 3 languages involved in the proceedings. After years of denial, the 6th Court recently ruled that the summons for appeal must be translated for non-Italian speakers if they do not speak Italian. It is evident that in retroactive illness proceedings, the citation, if they need to make a communication to you, including the judgment, usually involves the questioning by the delegated judge of the Court of Appeal, who tells you we will meet in But sometimes there may be a need to make a written communication, and it is good to know that under certain conditions, translation is required. It was traditionally said to always say no because it was stated that the summons to trial in appeal does not contain the charge. It does not contain the core. You know this because if it is a cognizance proceeding, you made the appeal, so you know what you are talking about. Nevertheless, the most recent ruling from the Sixth Court, followed by others, states that the summons concerns the complete exercise of the right to defense, and therefore, in some way, needs to be translated. The other issue I would like to mention relates to precautionary measures, but it also concerns mutatis mutandis, foreign precautionary measures, and European arrest warrants, specifically the problem of the nullity regime of the untranslatable precautionary order. There has been a referral to the United Sections. There is an order, which I repeat, you have all the details, which is 30,551 of the 23, decided on October 27th, 23, but the reasons are not yet available. And anyway, here in the provisional information, it is stated that if there is evidence, the resolution to which the problem exists was what happens if the order is not translated because there are various orientations. The term for taking the exams does not run. It is null. It is absolutely null. It is null in an intermediate regime. The institutions of the principle of law state that if the documents show the person does not speak Italian, the order issued that is not translated is null. If there is no evidence, it then emerges that this must be translated within a reasonable time, and if it is not translated within a reasonable time, we will see what they will write in the reasoning. It is unknown under what conditions it could become void. So these are also important matters that can influence the proceedings of European arrest warrants as they pertain to the exercise of the right to defense. So know this. You will find, I repeat, all the regulatory references, considering the other thing that we take for granted for those who deal with these matters, but perhaps it is good to say it. The laws here have preparatory works. Then there is the regulatory text, but it is the preparatory works, apart from the fact that the level lately is what I say. I can say it. In union law, the regulatory text is preceded by a series of recitals which state that it is considered that this directive is adopted because it must be understood that, and then there is the regulatory article. However, the regulatory article must be read in light of the preceding recitals because their interpretation refers to the obviously dry regulatory text while the recitals are discursive. Thus, it is true that if you go and take the regulatory text of the Union, there is not only the article, but first there are all, we would say, the premises, and then there is the regulatory article. There are two directives on information, Directive 13 of 2012 and Directive 48 of 2013, regarding specifically the European arrest warrant. There is an important point to make about the issue of having dual defense counsel, one in the issuing state and one in the executing state. This is a right enshrined in the directive because, obviously, let's assume a French warrant for a person arrested in Italy. So let's consider a classic, simple, trivial case. You are in Italy, but if there is some problem, for example, they have revoked the warrant, it is unclear whether the proceedings are over or not, and the data has not been updated. What do you do from Bologna? The directive states that you can appoint, that the person has the right to appoint, if not already appointed, a defender in the issuing state. One there and one here. And I say this as advice because it happens to me, as it does to all those who are lawyers, especially in the prison sector, let's put it that way, a few times. It's always good to seek someone out because you never know what might happen. For example, with France, we know very well, Dr. Piglio will know very well that whatever you have done, if you haven't gone to the trial, they won't hand you over. It is not clear why, you are perfectly aware, yet they do not send you there. At this point, you have the European arrest warrant pending for all the other 26 countries of the European Union, except for France as well. You are waiting for the prescription of the sentence in France, and normally there is the mistake of someone making a stopover, perhaps coming from a third country, making the stopover, and at that point they get caught. In Directive 48, it is stated that defenders here and from the location, defenders from the location, and this is good to know. From here, we also arrive at the fourth directive which concerns legal aid at the expense of the state, because, for example, it is stated in Directive 1919 that if you do not have the means, you can have a lawyer with legal aid at the expense of the state, here and there, in the issuing state and in the executing state. It is explicitly stated, so this is also something to take into account. The directive on state-funded legal aid, which is a matter notoriously fraught with disputes, in my opinion. We need to address on this issue. We have a fairly advanced single text compared to the rest of the European Union. In fact, we simply had to address the issue of tax crimes with the implementation and little more. Our legislation was essentially fine. What is important to know for our purposes, and what I believe is a space that everyone will need to reflect on, is that the Union obviously has 27 legal systems. It used to be 28, 27 different legal systems. The attempt is to bring them closer together, but there are very different, often irreconcilable foundations, especially in the principles. In the area of state-sponsored legal aid, there are two different systems: the income-based system as we have it, or the merit-based system as they have in other countries. Both are obviously acceptable. It's clear. But the directive states regarding Article 5, you find the number of articles unnecessary. It is pointless to cite them. It is written that it is not a clear, precise, and unconditional norm. Let us be clear. It is a norm that is, however, subject to interpretation, where it says that the judge should take into account, because in union law the conditional is often used. He should also consider the severity of the accusation and the resources that can be allocated. And so, in my opinion, this could open up a space both in the proceedings of the mandate of MAI, which we are discussing today, but also in general in the proceedings of cognition for a concrete assessment. The point is that one thing is the crime, punished with Romanian gastronomic penalties for road traffic violations, and another is a matter, for example, of homicide. This is obviously a different issue. And so, in my opinion, we could also consider asking the judicial authority, whether it be the Court of Appeal regarding today's matters or an assize court, a preliminary investigating judge, for an assessment stating whether this person is capable of securing an adequately prepared defense attorney who will follow the case with the necessary attention, regardless of whether the costs are 12,000 or as low as 0.01. This is a question that I believe we need to ask ourselves, and it is a point that requires work, because I repeat, we must realize that unfortunately, whether we like it or not, the costs of defense are also very high and may not be bearable for individuals. The directive also states, and this is especially important for today's meeting, that there should be a decision on assistance without delay. We, if you remember, had for a while that madness of absolute nullity. President Antoni, I believe, will recall it, whereby if you do not properly admit a certain term, there is a nullity of the proceedings which is evidently madness, a case of special nullity, completely alien to our system. However, the problem is that, obviously, in the directive, although not stated imperatively, it is understood that it is necessary to inform her that the girl has the right to be assisted at the state's expense or not, because this also simply involves the lawyer's meetings with the interpreter. The provisions for the compensation of interpreters, by definition, do not fall under the costs of the proceedings. They remain the responsibility of the state. Anyway, so also what comes with Andrea Guido to have the interview with the guy, then he asks for the request, not from me, but he obviously has to ask it from the judging authority with all that follows. In the directive, however, I say this to the lawyers, of course, because with responsibilities come honors, I always say. What is also written in this directive, that in addition to the obligation of training and usual matters, it is stated in the directive that there should be quality controls on the royal service, just like for interpreters. For the defenders, the quality of the service is provided. It is not written exactly like that. I say it this way so that we understand each other. Therefore, we need to know this. Before being placed on the lists for office assignments, for example, in the Court of Appeal, particularly in traditional matters, it is advisable that public defenders are individuals who have a basic understanding of the subject matter and are knowledgeable about it. Instead, I believe that it is, for common reasons, I imagine, a substitute for the Attorney General in Bologna. I assume he sees him regularly. President Antoni will have seen him, and civil lawyers can also happen to be present. And if the matter is so complicated, so technical, as we have said, as the first two reports have stated, as I am trying poorly to express, as the next two speakers will tell you, well, according to union, law, the legal assistance, service at the state's expense provided by a defender must be of adequate quality. Of adequate quality for the proceedings. It is today, it has always been. I have some healthy doubts. These are things, I repeat. I am speaking in general because in the details you will find, I repeat, all the legal references we are somehow discussing. Here, I have used my time, and I will only say one thing. It is good to have a basic understanding of union law, because in 2024, we cannot overlook it. I am now differently new, as I studied when I was still in the European community, pre-Maastricht, so I had to study it all over again. Unfortunately, this is a subject that is essentially unknown, so it needs to be studied. Moreover, it is a subject that concerns personal freedom and involves procedures that can sometimes be simple, but at other times very complicated, such as organized crime, which has been perfectly discussed in the preceding report. I believe that there needs to be an effort from everyone, from the judiciary, but also from the defenders, to ensure not just minimal rights, as the director says, but to guarantee effective rights to those who in some way find themselves in trouble because they will be convicted, but they still have rights. We do not cut off ears, for example. And in the European Union, we should not cut off ears. If we are to be judged, the subsequent report will address it. We are presumed innocent, and therefore I believe that attention must always be very high. I thank you for your attention, and I will conclude by saying something that I read on the train while arriving. I have it here in the latest issue of Criminal Law for the Obsessed, because I will show it to you later. I am still subscribed to the magazine Cartacea, that is the Italian forum, Criminal Cassation, and there is a nice overview of the latest decisions of the Court of Justice in this matter. It arrived in my office yesterday. I unwrapped it this morning, and so it's there. I can show you if you want. In the page references, there are all the latest decisions regarding the European arrest warrant. Thank you for your attention.